Chapter 28. Injunction against interference with freedom of trade or employment, combinations, strikes, boycotts, etc. Analysis. Section 585. When such injunction is granted. The question whether an injunction will be granted against a combination of labor or capital is answered by an examination for three elements. These elements are: first, is a legal right invaded or about to be invaded? Second, is the invasion of this right by unlawful or unjustifiable means, on with an unlawful or unjustifiable purpose? Third, is the remedy at law for such an invasion of plaintiff's right inadequate? Section 586. A question of newly defined rights. The rapid increase of powerful combinations of labor and capital the past few years has opened a new field to legal exploration, and compelled a new determination of the rights open to an invasion by such combinations, and required new tests of what constitutes unjustifiable means and purpose. The line between combination that is fair competition and combination that is unlawful is being drawn tentatively and at varying points by the different jurisdictions. The question of injunctions against combinations, so far as there is a new question, is largely one of the lawfulness of the combination, considering its purpose and means. And this question is largely one for a new definition, viz., the nature of the working man's property in his labor, and the extent of the owner's rights in the management of his business, how far the working man may be protected from the interference of third parties in his contract to labor, or in his more recently conceded rights to continue in employment when not under contract and to seek and have work free from outside influence. Likewise, as to the employer's rights, to have his contracts protected from irresistible influence of combinations, to have his non-contract labor let alone, to have labor and custom flow freely to him, and generally the intangible property of his business free from interference otherwise than in fair competition. Thus, it appears that the principal part of the problem of the remedy of injunction against combination of labor and capital is not so much the question of the injunction, for that is dependent on settled principles of equity jurisprudence, but is rather the determination of the substantive law as to the right itself. For instance, the question, will an injunction be granted to restrain a combination from procuring the discharge of a workman or the loss of a customer, depends primarily on the point, are such acts actionable wrongs? Section 587. How these rights may be invaded by the combination. For the reasons just considered, to understand the remedy of injunction against such combinations it is necessary to determine, first, the nature of the right invaded by the act of the combination of labor or capital. And this determination can best be made by analyzing the problem into its parts, a natural division of the ever-increasing mass of data arising from the exercise of the weapon of combination, from the point of view of its legal significance, gives the following analysis. Section 588. Analysis of the Treatise. The legal wrong arising from 1. Inducing or procuring a breach of contract by the combination exercising its power upon the different parties, a. the employer, b. the employee, c. the customer or dealer, or otherwise by interference with the performance of outside business contracts. 2. By interference with the parties where no contract relation exists. The more common case, as this is done by the combination procuring by its great power the discharge or withdrawal of workmen not under contract, or the loss of customers or suppliers not under contract. The analysis of the rights may be thus stated: where no contract relation exists, a. right to continuance free from interference, b. justifiable interference, persuasion, c. procuring the discharge or withdrawal of workmen or the loss of customers. 3. A third phase of the analysis extends to an interference beyond even the relation where there is no contract between the parties, but merely the possibility of their entering into some relation, as to whether there is such a legal right, which equity can protect from the power of the combination. The search for this right, aptly termed that of probable expectancy, leads in the analysis to the combination preventing the free flow of labor to the employer, of custom to seller, and of employment to the laborer, and may be expressed in the analysis of these legal rights as the right to have labor or trade flow freely, or the right of probable expectancy. There remains a more general right which may be termed the right to have personal freedom protected. Some of the rights previously discussed are derived to some extent from this source, as well as from the right to property, but have been recognized as specially existing rights by the courts. The more general right of personal liberty is thus a residuum to draw upon in working out these rights, but is also to be regarded by itself in seeking the foundation for the injunction. Section 589. Procuring or inducing a breach of contract as a legal wrong. As to the first of these, procuring or inducing a breach of contract, the old law which confined the remedy to enticement of servants from masters has been from time to time extended, beginning with Lumley v. Jye and Bowen v. Hall superscripto in England, so that today it is a fair statement of the law, in the words of Lord Macnaghten, quoted in Quinn v. Letham with approval, that it is a violation of a legal right to interfere with contractual relations if there be no sufficient justification. In Jersey City Printing Company v. Cassidy, the court said, that the interest of an employer or employee in a contract for services is property is conceded. And, it continues, causing the disruption of a contract relation, to the injury of one of the contracting parties, is now very generally recognized as actionable in the absence of sufficient justification, and the question in every case seems to turn on justification alone. This represents the view generally taken by the American courts called to pass upon the question of late years. But some American courts have not yet accepted this view. Section 590. By acting upon the employee, an injunction will issue against a combination of men inducing workmen to break their contracts with their employers, if their act is without justification. The Glassworkers Union induced several apprentices to join their union, knowing that they were under contract not to join any union. An injunction was granted against them individually and as members of the union, restraining them perpetually from persuading said apprentices to break their contracts by enticing them into the union. Many courts assume that the injunction will be granted as a matter of course when it is shown that the contracts with employees are about to be broken so as to withdraw the men from employment, although some go into the pertinent question as to whether the injury threatened really is irreparable and without adequate remedy at law. Section 591. By acting upon the customer or dealer, where a combination procures or induces a customer or dealer to break his contract, the act is unlawful, if without justification, and may be enjoined, under proper circumstances, by the seller. Temperton v. Russell decided that the principle established by Bowen v. Hall, viz., that the actionable wrong committed by one who induces a party to a contract to break it, in tending thereby to injure another person or to get a benefit for himself, is not confined to contracts of personal service. Temperton v. Russell, though weakened by Allen v. Flood, is now re-established by Quinn v. Letham. The leading point established, however, by Allen v. Flood, i.e., a malicious motive does not make an otherwise lawful act unlawful and actionable, seems to be restated in Quinn v. Letham, in the old form that an act inducing one party to break his contract or business relations, while lawful if with justification, is unlawful without such justification. Section 592. By interference with the performance of business, an injunction will be granted against a combination attempting to prevent the performance of the employer's contracts where the interference to business threatens its destruction. Thus, where a striking union, in order to coerce an employer, a plumber, so intimidated his workmen where they undertook to carry out contracts to do plumbing, that the work was prevented, an injunction was granted on the ground that his business was being destroyed. The court said, the right of plaintiff to carry on his business and to carry out contracts which he had made was a valuable property right, and no less intrinsically property than if it were merchandise. The right to carry on a lawful business is a property right, and will be protected. Section 593. Interference where no contract relation exists. A similar series of questions is presented where the workmen or customers are not under contract. Is it an actionable wrong to procure or induce the discharge or withdrawal of workmen not under contract? or procure or induce the withdrawal of customers not under contract. If these acts are actionable wrongs, an injunction will evidently be granted under conditions admitting the equitable remedy. Section 594. Right to continuance free from interference. While in some cases the courts try to distinguish between the contract rights and these less clearly defined rights, there now seems to be a general consensus that there is a right to continue in employment, a right to have men continue in employment, and a right to have customers trade free from intimidation, that these are property rights, and that a combination to interfere with these rights otherwise than in fair competition must show justification. The great divergence of the cases is not on the point of the existence of the rights, but as to what constitutes justification, except that interference with these rights by mere persuasion is not actionable, and will not be enjoined. The two leading cases which have refused interference in this class of cases are Allen v. Flood, in England, 1898, and National Protectivation v. Cumming, New York, 1902. In the United States, the force of Allen v. Flood has been greatly weakened by the House of Lords in the late great case of Quinn v. Letham. That case says Allen v. Flood is to be considered as deciding merely that giving information by certain workmen, through an agent, that they had decided to quit if the plaintiff should be retained, was not actionable. Section 595. Justifiable interference. Persuasion. The American courts generally agree that interference with the employee's right to continue in employment, or the employer's right to have such continued employment, not under contract, where such interference is by direct coercion or intimidation of the employee, is ground for an injunction. But when the interference with these rights is by persuasion and peaceable means, it is not generally in the American courts considered unlawful, and an injunction will not be given. In England, the injunction extends to interference by persuasion, but this extension rests upon an Act of Parliament. The gist of the American cases seems to be that while there is a right to continue in employment and a right to have men continue in employment, it is fair competition for a combination to interfere with either of these rights by persuasion or any peaceable means, but not fair competition to use coercion or intimidation. Hence such interference will be enjoined. These rights are usually considered from the point of view of the employer asking an injunction for interference with his right through interference with his employee, as most of the cases arise in this manner. Section 596. Procuring the discharge of workmen. The case of the employee seeking injunction is found where his discharge is procured by coercion or intimidation of his employer, as by means of a threatened strike or boycott. The line between the right of the non-union man to be protected from injury, and of the union man to better himself by fair combination, is so close that the cases fall on both sides of it. Thus, in a late case, where the members of a union threatened to call a strike if the employer did not discharge members of a rival union in his employment, the court said this was a combination to injure a man's property right, his right to work, and was an unlawful act which equity would restrain. It said, where unions combine to prevent others obtaining work by threats of a strike, or to prevent an employer from employing others by threats of a strike, they combine to accomplish an unlawful purpose, which courts are bound to restrain. But under similar circumstances, the New York Court of Appeals, in National Protectivation v. Cumming, reversed a decree which had granted an injunction against one labor union procuring the discharge of members of a rival labor union by threatening the employer with a general strike. Parker, C. J., put the decision on the ground that the union had a right to strike, and hence a right to give its reasons for intending to strike, that such a lawful act, though causing the discharge of other workmen, needed no justification. But if it did, it was found in the right to further its own interests, and at least no malice could be presumed. The American cases generally have been in line with Erdman v. Mitchell, rather than National Protectivation v. Cumming, but some later cases are following the latter, procuring the withdrawal of workmen or loss of customers. The question, whether the workman, though not under contract, will be protected by injunction from having his discharge procured by a combination of his fellow workmen operating on the fears of his employer, is paralleled by the claim of right on the part of the employer to be protected by equity from hearing his non-contract labor or customers withdrawn from him by the exercise of the power of the combination of labor. The courts answer the questions similarly. In England, Quinn v. Latham has undoubtedly restated the law along the lines of Temperton v. Russell, contrary to many of the conclusions from Allen v. Flood, so that it is now actionable to procure discharge of a customer not under contract, or of an employee under contract, and by inference an employee not under contract, where there is not sufficient justification and a desire to punish a fellow workman for not joining the union, by forcing his discharge in order to benefit the union by strengthening its power, is not sufficient justification. But it is not actionable to inform an employer of a determination to strike because of certain workmen employed unless they are discharged, where it is given as information. This much narrowed rule seems to be the present interpretation of Allen v. Flood, since the decision of Quinn v. Latham. In the American cases it is generally held that procuring the loss of one's customers by threats and intimidation, not mere libels of complainants, will be enjoined. Section 597. Does motive affect liability? These cases really separate on the question upon which Allen v. Flood wrought such confusion, viz., does motive constitute an element of a civil wrong? The majority of the judges that took the view that the defendant's motive could not be considered as affecting his liability. Chief Justice Parker, in National Protective Association v. Cumming, stated the same opinion of the law. Such is the view of the several American courts that have refused to enjoin a threatened strike or boycott by unions or associations having a purpose to obtain an advantage for themselves by procuring employers to discharge workmen or customers to leave their supplier. Thus in Bonn MFG Company v. Hollis, the court declared, if the act be lawful, one that the party has a legal right to do, the fact that it may be actuated by an improper motive does not render it unlawful. But the majority of American courts do not accept this view as the law, as it appears in labor and trade disputes. The recognized leading case of Walker v. Cronin says the act of procuring the workman to leave was wrongful when done without justification, and this constituted malice. The leading American writers agree with this trend of the American cases, and do not accept the dictum of Allen v. Flood that a malicious motive cannot make an otherwise lawful act unlawful. Professor William Draper Lewis concludes an examination of the labor and trade cases on this point thus: though there are cases to the contrary, the rule is to consider the motive of the defendant as a factor in determining the question of his liability for the harm which his act has caused the plaintiff. Professor James Barr Ames says, the dictum that our law never regards motive as an element in a civil wrong is as far from the truth as would be the statement that malevolently to damage another is always a tort. The truth lies in the middle. In certain cases, in spite of the wrongful motive of the actor, malevolently to damage another is lawful, either because the act is merely the exercise of an absolutely legal right, or because it is justified by paramount considerations of public policy. Except in such cases, however, willfully to damage another by a positive act and from a spirit of malevolence is a tort, even though the same act, if induced by a rightful motive, would be lawful. Professor Ames eliminates the word malice from the discussion because of its different meanings, which confuse the issue. Section 598. Right to have labor or trade flow freely. The right of probable expectancy. The most recent extension of these rights which may be invaded by a combination is the right of labor or trade to flow freely. Has the laborer a right to go to an employer to seek labor, which equity will protect? Has the employer a right to have labor flow freely to him, so that he may call on equity to enjoin interference with a man who as yet has no relation with him, but whom he is desirous of having as employee? Has one a right to have the way protected between him and possible customers or suppliers? The most recent casks answer each question affirmatively. Stevenson, v. C. in an able statement of this modern development, draws this conclusion: our law, in its recent development, undertakes to ensure to him, the employer, not only that he may employ whom he pleases, but that all who wish to be employed by him may enter into and remain in such employment freely, without threats of harm, without unreasonable molestation and annoyance from the words, action or other conduct of any other persons acting in combination. The right being recognized, the employer is given an injunction against a combination which seeks to interfere with his probable expectancy of trade or labor, his right to have labor and trade flow freely to him, when the interference is by coercion or intimidation. But endeavoring to prevent persons seeking employment of complainant from accepting such employment by conveying information, and by orderly and peaceable persuasion, is lawful and will not be enjoined. The right of trade and labor to flow freely is therefore not as complete as the right to have a contract free from the interference of third persons. But it is something more than the right of personal liberty which it seems to have developed from. A part of the employer's right to have trade and labor flow freely to him is the right that access to his property should not be interfered with. Section 599. The right to have personal freedom protected. The primary right that one's personal liberty should not be interfered with by combinations of persons is protected by equity. Thus, an interference with the right of the laborer to travel on the highway, by means of numbers of men or by physical force, will be enjoined where its continuance is threatened. Section 600. Injunctions because of the means employed. Intimidation. The question of injunction against combinations of labor unions will next be considered from the point of view of the means employed. When will an injunction be given against interference with one's business or employment? The injunction is usually sought by the employer, although the act sought to be enjoined is most frequently operative directly on his employees, but brought by whichever party. The main test is, do the means used amount to intimidation? The ordinary means used by the combinations of labor to accomplish their ends are the strike and the boycott, and as incidents to these, picketing, patrolling, congregating in numbers, threats, violence, coercion, circulars, placards, and blacklisting. Section 601. The strike. Although formerly, at common law, a combination to secure higher wages was an unlawful conspiracy, now the right to combine and strike is everywhere recognized by statute or decision. But an order to strike which would cause a breach of existing contracts between the workingman and employer may be enjoined, if there is not sufficient justification. And an order to unions to strike where the strike was merely sympathetic, and would interfere with interstate commerce, was enjoined by the federal court on the ground that it was an arbitrary strike without cause, and used for purpose of a boycott. Section 602. Threat to strike. Where a threat to strike is used as a means of intimidation of an employer to procure discharge of non-union or rival workmen, will an injunction be granted. The cases have shown a recent tendency to diverge on this point. The English cases prior to Allen v. Flood held it to be an unlawful act. Allen v. Flood held that information, amounting to a threat, that certain union workmen would leave if plaintiffs were not discharged was not actionable, though malicious. But Quinn v. Letham says that a threat to call out men, given to an employer by a union to procure discharge of other men, is actionable. The court would have undoubtedly granted an injunction in the case. The point was expressly made by the Court of Appeal in Giblin v. National Labor Union, 1903, that a threat by a union to cause a strike if certain workmen were not discharged was actionable, and leave was given to apply for an injunction if necessary. In the United States the present weight of authority is with Erdman v. Mitchell, that a threat to strike, made by a combination, unless other non-union or rival union men be discharged, is a combination to injure another's property right by the coercive means of intimidating his employer, and will be enjoined. But, as has been already noticed, there have been recent strong decisions the other way, notably National Protectivism v. Cumming, New York, 1902, and Jersey City Printing Company v. Cassidy. The latter case said, union workmen who inform their employer that they will strike if he refuses to discharge all non-union men are acting within their absolute right and are merely dictating terms on which they will be employed. Section 603. Intimidating threats. Where the intimidation takes the form of threats of violence, an injunction lies as matter of course, as it would against interference by violence itself. Where no actual threats of violence are made, the determining factor is whether a threat of physical harm is implied from the acts, or reasonable men would be put in fear from defendants' acts so that they are coerced in their will. The cases of picketing, patrolling, congregating in numbers, and blocking the highways are thus tested. Picketing will be enjoined where the court is satisfied that the purpose or effect is to intimidate, likewise as to congregating about employers' premises or workmen's homes, or in the highway in numbers, where the inference of intimidation is reasonably drawn. Section 604, Picketing. Picketing for the purpose of peaceful persuasion of employees or customers, or for the purpose of obtaining information, though interfering with plaintiff's business, is lawful competition, and will not be enjoined. But the mere presence of large numbers, though for an ostensible peaceful purpose of persuasion, may be enjoined as operating unfairly on the will of employees and customers. Where the presence of numbers, though not intimidating, yet actually obstructs access to, or egress from, complainant's place of business, or interferes with freedom of the highway, an injunction will be granted on the ground of a continuing nuisance, a continuing trespass on plaintiff's property, though only for the purpose of persuading his workmen to quit, will be enjoined. Section 605. Moral intimidation. What constitutes intimidation? There need be no actual threats of physical harm, but the use of opprobrious epithets and vile language, the act of following workmen to their homes, surrounding or watching their homes, may imply danger of physical harm, and will then be enjoined. A more difficult question is where the intimidation is not through fear of physical harm from the acts of defendant's combination, but what has been termed by Lord Justice Fry moral intimidation, where the will and conduct of a person are coerced by a combination of defendants to produce some loss, in a social way or of property. Lord Justice Sterling said that continued threats to an employer to call a strike if certain workmen were not discharged were in the nature of molestation or coercion, and though no physical harm was threatened, the act may be illegal. The question of social pressure as a form of intimidation was considered in Vigilan v. Guntner, where the court observed, intimidation is not limited to threats of violence or of physical injury to person or property. It has a broader signification, and there also may be a moral intimidation which is illegal. The injunction there issued included social pressure among the forms of intimidation it was directed against. In his dissent, Holmes, J., pointed out that the injunction issued which forbade the defendants interfering with the plaintiff's business by any scheme, organized for the purpose of preventing any person or persons who now or may hereafter be, desirous of entering their, plaintiff's, employment from entering it includes refusal of social intercourse, and even organized persuasion or argument, although free from any threat of violence, either express or implied. In Plant v. Woods, 1900, defendants in combination were enjoined from interfering with employment of plaintiffs, members of a rival union, by intimidating or attempting to intimidate, by threats, direct or indirect, express or implied, of loss or trouble in business, or otherwise, any person, etc. The court said, this threat to strike means that those who have ceased to work will by strong, persistent, and organized persuasion and social pressure of every description do all they can to prevent the employer from procuring workmen to take their places. The contrary view was taken in Kthler v. Altman, where it was held that letters written by a principal of a school to parents threatening pupils' suspension if they visited plaintiff's store, written as part of a systematic effort to damage plaintiff's business, did not constitute intimidation within the legal meaning of the term, and was not actionable. Section 606. The boycott. The question of moral intimidation is seen to be crucial in connection with the other great weapon of combination of workingmen, the boycott. Some courts define boycott as always including intimidation and coercion. But it seems well to distinguish between the boycott of persuasion and the boycott of intimidation and coercion. Section 607. Boycott of persuasion. Generally courts will not enjoin the boycott of persuasion, as where a labor union circulates a card that a house is unfair, asking union men to keep away, or notifies prospective customers that plaintiffs are unfair, although some courts will enjoin even the boycott of persuasion. Section 608. Boycott of fear. But where the boycott goes beyond a request not to deal with plaintiff and expressly or impliedly threatens a loss to the third party, as a customer, if he does deal with plaintiff, as by threatening to boycott him, then the courts generally will issue an injunction. In Hopkins v. Oxley Stave Company the court said, in granting an injunction against the union's boycott, that the combination of defendants undertook to prescribe the manner in which the plaintiff company should conduct its business, and to enforce obedience to its orders by a species of intimidation which is no less harmful than actual violence. In a recent case, in granting an injunction, the court took the ground, it is unlawful for a labor union to attempt to induce or compel complainant to adopt a particular mode of doing his business by persuading or inducing other persons not to deal with him. Some courts are very ready to imply an intimidation in the boycotting circular or letter, although none exists on the face of it. Thus, in Sherry v. Perkins, an injunction was granted against a boycotting banner bearing the words, "Others are requested to keep away from Sherry's," on the ground that the banner was a standing menace and a nuisance. Likewise in the early English case of Springhead Spinning Company v. Riley, where placards were enjoined which said, "Well-wishers wanted not to trouble Springhead Spinning Company until dispute is settled." Some discredit was later thrown on this case. In a later American case, the court in enjoining a boycotting circular remarked, "A circular containing no words of threat is nevertheless a boycotting circular when it was intended and understood to threaten customers to whom it was sent." The rule of these cases would seem to be that the instrument of boycott is to be read in the light of the circumstances, and if it naturally tends to intimidate the recipient, it will be enjoined. The attitude of a majority of the courts is against the boycott of intimidation, though only moral intimidation, and the injunction is given as matter of course. One federal court states that it knew of no case in which an injunction was refused against a boycott. Section 609. Boycott as a weapon of competition. But there is vigorous reasoning to the contrary, looking upon the boycott as a proper means of competition. Caldwell, J., in dissenting in the Oxley-Stave case, said, "These, the strike and the boycott, are labor's only weapons, and they are lawful and legitimate weapons. And so long as in their use there is no force or threats of violence or trespass on person or property, their use cannot be restrained." Thus, he would admit the boycott of moral intimidation, as coercion through threatened loss of business, as a proper instrument of competition. Holmes, J., takes much the same view. Speaking, in dissent, of the intentional inflicting of harm in free competition, he says, "It cannot be done by force or threats of force. It may be done by persuasion. It may be done by the withdrawal, or threat to withdraw, such advantages from third persons who have a right to deal or not to deal with the plaintiff, as a means of inducing them not to deal with him either as customer or servants." Several recent cases have gone upon this view of lawful competition and have refused an injunction against a boycott by moral intimidation. In a Missouri case, 1902, it was refused on the ground of interference with the constitutional right of free speech. In an Oregon case, although the threats of boycott to plaintiffs' customers caused their withdrawal, injunction was refused on ground of not being an irreparable injury. Another court says no injunction will lie unless the boycott interferes with a relation of contract between customer and plaintiff. These latter boycott cases are proceeding on the same line as the threat to strike cases, of which National Protective Association, SUPRA, is the type. It is the question of drawing the line between fair and unfair competition. Some recent writers and judges have asserted that the line is drawn more rigidly against labor combinations in competition with capital, than in case of conflict of combinations of capital. The injunction against a combination of members of a labor union for boycotting is usually granted, without regard to whether there is any contract relation between the customer and plaintiff. Whether the boycott is in the form of circulars, letters, advertisements, placards or banners, or any other means of communication of defendant's purpose, the same test applies. Is the coercion of a third person's will to the injury of the plaintiff? Where mere information is conveyed or persuasion used, no injunction should be granted on the ground of the means used. Section 610. The blacklist. The form of boycott known as the blacklist seems to be treated with more consideration when used by capital than when used by combinations of labor. Thus, where a mill corporation sent out a blacklist of striking employees to other mill corporations, and there was a combination not to employ plaintiffs, except at the old price, in their old places, no injunction was allowed. An employer may keep a blacklist and show it to other employers. But where members of a union combine and threaten to blacklist a non-union man, it is held to be a form of intimidation and may be enjoined. The distinction, though not often drawn, would seem to be the same as in the other forms of boycott and the strike, i.e., where the blacklist is an instrument of intimidation it should be enjoined, but where it is a means only of information it is a legitimate weapon of competition. Section 611, Grounds for the Injunction. The grounds that determine whether an injunction will be granted or refused do not lie to any great extent in the element of combination or conspiracy per se, but in the effect upon the plaintiff's rights, although the law will sometimes take cognizance of acts done by a combination of persons which would not give rise to a cause of action if done by an individual, because of the power residing in numbers to do harm. The main question the courts seek to answer is, has the plaintiff a right, as to continue in employment or be employed or have trade flow freely to him, which right is being infringed unlawfully by defendant's conduct. These rights are usually found or assumed to be threatened in a way for which the law can give no adequate remedy. To a large extent, in granting the injunction in these cases, the courts have not gone into the question whether the injury was irreparable, but assumed that as matter of course. Thus an injunction was granted, recently, against defendant's boycotting plaintiff, on the ground of unlawful interference with plaintiff's property rights, with no mention that the injury was irreparable. And this is true in many cases. Section 612, Destruction of complainant's business or vocation. This attitude doubtless arises from the consideration that the nature of the wrong threatens the destruction of plaintiff's property in his business or right to work, or at least a serious injury for which the remedy at law is inadequate. This attitude has led to the practice of granting an injunction although in strictness the injury was not irreparable, particularly in the federal courts, where the injunction seems to be granted over-readily. In Printing Company v. Howell, an extreme view the other way was taken. A printers' union had induced plaintiffs' men to quit, had by threats of boycott caused loss of many customers, and it threatened to carry the boycott to the death. The court refused the injunction on the ground that the injury was not irreparable, and that an injunction should not issue unless the injury was irreparable. In most jurisdictions an injunction would have issued here. Section 613. Multiplicity of suits. Multiplicity of suits from the number of defendants in these cases is often given as a ground for the injunction, but in all cases found that is not the sole ground. Likewise, the insolvency of defendants, while suggested with other grounds, has not of itself been made the sole ground for an injunction. The fact that the defendants are without means does not in any way change the complexion of the case. The court observed in refusing an injunction against a boycotting circular. Section 614. Continuing injury. Continuing interference with plaintiff's business is a frequent ground, or in general, a continuing injury to the plaintiff's right of person or property, as the remedy at law would be inadequate. Section 615. Nuisance. Nuisance may be a ground for the injunction in certain of these cases, as, for instance, an obstruction to access to plaintiff's property, or an obstruction of the highway so as to interfere with plaintiff's right to travel freely to his work, or to seek work. In Vigilan v. Guntner, there was a patrol of 2 men placed in front of plaintiff's premises, and the court granted an injunction, giving as one of its reasons, the patrol was an unlawful interference both with plaintiff and his workman, and when instituted for the purpose of interfering with his business, it became a private nuisance. Section 616. Interference by intimidation with legal right. The injunction may be granted simply because of the right invaded, without regard to the fact of numbers or of combination. This is clearly the ground of a large proportion of the cases of injunction against combinations of labor unions. But the right to the injunction may be due to the mere presence of numbers, as thus constituting a nuisance, as in obstructing access to plaintiff's premises, or as creating the element of intimidation from the mere presence of numbers or from the combination of many. The crux of the matter, however, is not in the combination or the numbers, but in the effect. The intimidation. This intimidation might as well come from a single individual, if he were powerful enough. It is this element of intimidation arising out of mere numbers or of a combination of numbers to plaintiff's detriment that often makes that actionable or enjoinable which would not be when done by a single individual, for then plaintiff, customer or employer, ordinarily would not be coerced through fear. Section 617. The combination may be enjoined as a conspiracy. The injunction is often rested on the ground of restraining a conspiracy. But whether there is a conspiracy or not is to be answered by looking at the questions already discussed. For the test of a conspiracy is, 1. Whether the purpose of the agreement of the combination is unlawful, or, 2. Whether the means used to carry out the agreement are unlawful. Either of these conditions makes the agreement into a conspiracy which may be enjoined, where property rights are threatened with great injury. But adding the word conspiracy does not aid to any great extent. The court in Hopkins v. Stave Company says, a conspiracy to compel a manufacturer to abandon the use of a valuable invention bears no resemblance to a combination among laborers to withdraw from a given employment as a means of obtaining better pay. Here the purpose was lawful, to obtain better wages, by getting the employer not to use hooping machines. But the means were unlawful, the court said. The means were in the use of the boycott as a weapon upon complainants' customers. So it may be said that combinations as such are not unlawful. And to determine whether the combination amounts to a conspiracy which may be enjoined, it is necessary to see whether the means used, or the purpose in view, would be ground for an injunction. In Longshore Printing Company v. Howell, an injunction against a conspiracy to boycott plaintiff was refused on the ground that the injury was not irreparable. Section 618. Mandatory Injunction. It seems clear that a mandatory injunction could seldom apply to a combination of labor, as the prohibitive element of personal service is ever present. The decree by Jenkins, J., giving an injunction which prohibited members of a combination from quitting in a body the service of a railroad which was in the hands of a receiver, was evidently contrary to the equitable principle that compulsory service will never be required by a decree of equity. This view was taken in Arthur v. Oakes, which reversed the decree of Judge Jenkins on that point. But so long as workmen continue in the service of a railroad, equity will by mandatory injunction compel them to accept and transmit any and all interstate traffic, and will not permit them to boycott an offending railroad. While equity will not compel workmen to remain in service, it will enjoin a labor union official from ordering a strike when the effect would be to interfere with interstate commerce, the only ground for the strike being sympathy with strikers on another road. Equity will not permit men in the railway service to leave their service at a time dangerous to the public. Section 619. Where act enjoined is a crime, it is often offered as an objection to an injunction that the act threatened is a crime, but it is everywhere the rule, following the general principle in equity, that where there is ground for equitable interference, as where an irreparable injury is threatened to property, the fact that the act is also a crime is not a reason for refusing an injunction. But equity has no criminal jurisdiction, and will never enjoin a combination to commit a crime simply for the purpose of preventing a crime. Section 620. Against whom does the injunction run? An important question in attempting to prevent acts by combinations of labor is, against whom must the injunction lie? Whether persons not named as parties defendant may be named in the injunction, and whether persons not named at all may be subject to the injunction. Certain cases in the federal courts have answered both of these questions affirmatively. It is undoubtedly sound to make the injunction run against persons not named as parties, if they are somewhat definitely determined by the writ itself. But the sweeping injunction that includes all who cross its path, though neither party is defendant nor named in the injunction, is properly criticized. In this country an injunction against a trade union by its name is nugatory, as there is no form of incorporation, although in England it is now recognized that by the Acts of Parliament the union is an incorporation for certain purposes, including that of liability in its trade union name. In this country the injunction is almost universally directed against the officers and members of the union, as individuals acting in combination. As it is impossible to name all the members of a union in a bill for an injunction, it is enough to name as parties the officers of the union and a representative portion of the members, and then let the bill call for injunction against them and all other members not named. Section 621. Preliminary injunction against a combination. The usual rule as to preliminary injunctions applies as against a combination of labor or capital. This rule is stated by Sanborn, J., and is quoted with approval in Harriman v. Northern Securities Co., viz. A preliminary injunction maintaining the status quo may properly issue whenever the questions of law or of fact to be ultimately determined are grave and difficult, and injury to the moving party will be immediate, certain and great if it is denied, while the loss or inconvenience to the opposing party will be comparatively small if it is granted. Section 622. Combinations in restraint of interstate commerce. A combination of labor to use such means to attain their purpose that the result is an obstruction of the United States mails and an interference with interstate commerce, constitutes a conspiracy and will be enjoined. The inferior federal courts place the power to enjoin the interference with interstate traffic entirely on the Act of 1890, which Act expressly gives the power to prevent by injunction a conspiracy to interfere with interstate commerce. This Act of 1890 was directed against combinations of capital, but from the first, the federal courts held that it included combinations of labor as well. One federal judge declared that before the Act of 1890 a federal court could not have enjoined such an interference. But, in the leading case of United States v. Debs, the Supreme Court took a much larger view, and held that where officials and members of a labor union, in order to enforce a boycott against the Pullman Car Company, conspired to obstruct trains carrying mail and interstate freight and passengers, and to interfere with the service generally, an injunction would be granted on the broad ground of an interference with the exercise of the national powers of the federal government, that the United States had a property in its mails which gave it a technical right to an injunction against their obstruction. But further than this, any obstruction of a national way of commerce was a nuisance and an interference with a sovereign power and could be enjoined by the equitable arm of the government. It did not base its decision on the express Act of 1890 which the Circuit Court had used as its authority to grant the injunction. Section 623. Combinations of capital. Boycotting combinations. The general results found in reference to injunctions against combinations of labor apply to combinations of capital in analogous cases. Thus, where the basis of the conspiracy is the illegal means of the boycott of intimidation, though moral intimidation only, by a combination of capital, on principle an injunction should lie if the injury is continuing or irreparable, equally as against a combination of labor. Thus, where manufacturers and dealers in plumbers' supplies agreed with an association of master plumbers not to sell to any master plumber not in the combination, and that the association should boycott any dealer found selling to a non-member, an injunction was granted. There are many decisions to the same effect. In Jackson v. Stanfield, the court said, "The great weight of authority supports the doctrine that where the policy pursued against a trade or business is of a menace in character, calculated to destroy or injure the business of the person so engaged, either by threats or intimidation, it becomes unlawful. It is not a mere passive, let alone policy, a withdrawal of all business relations, intercourse and fellowship that creates the liability, but the threats and intimidation shown in the complaint." Section 624. The boycott is the unlawful element. The essential element making the combination unlawful is its boycotting feature. There are authoritative cases contrary to these. Thus, where a combination of master plumbers sent notices to wholesale dealers not to sell plumbers' supplies to non-members of the association on penalty of the withdrawal of the patronage of members, the court refused to grant an injunction, saying the interference with complainant trade was justified as fair competition, and trade should be free so long as the methods were not of fraud, misrepresentation, intimidation, coercion, obstruction, or molestation of a rival. The court thus refused to acknowledge that the moral intimidation involved in the threat of the combination to cause business loss to the wholesale dealers in order to coerce them amounted to an intimidation it would consider. The leading case of this group is that of Bond Manufacturing Co. v. Hollis. A number of retail lumber dealers formed an association, agreeing not to deal with any wholesale dealer who should sell directly to the consumer. The plaintiff claimed their association amounted to a combination to boycott, and that he suffered from their boycott. The court refused him an injunction, holding that the association had the right to withdraw its patronage collectively, even though used as a boycotting measure of coercion. It would seem sound to draw the line where the element of boycotting came in, even though only in the form of moral intimidation through fear of loss of business. Section 625. Mere loss of business not ground for the injunction. But it is equally clear that a mere direct loss of business is no ground for objecting to a combination, as in the much-cited case of John D. Park and Sons v. Druggistson, where certain wholesale druggists and manufacturers of a proprietary medicine fix a price to retail the medicine and agree that the latter shall not sell to any wholesale druggist, except at retail prices, who will not join the association and maintain the price. The injunction was denied. There was no element of boycott. It seems clear, as a general principle, that no injunction will be given against an injury resulting from a combination of several to withdraw from business relations with complainant, where there is no element of coercion or intimidation of complainant or of any third party in any form. The Mogul Steamship Company case set an authoritative standard of what is a lawful combination in another direction. In this case, a number of ship owners, in order to get control of the tea-carrying trade, combined and depressed the freight rates so that complainant was unable to get cargoes at rates which would enable him to carry on business. The defendants also threatened to dismiss certain foreign agents if they loaded plaintiff's ship. The course of defendants was held to be fair competition. This case has been quoted with approval as setting a proper standard of fair competition in both England and the United States generally. Section 626. Where the combination is a monopoly, a combination of several persons or corporations to create a monopoly, which would be an illegal combination at the common law, may be restrained by injunction as a threatened danger to the public welfare. Thus, where a railroad corporation, which also virtually controlled large coal mines, leased certain coal-carrying railroads for the purpose of controlling that coal region by combining, in effect, carriers and coal producers, equity looked to the substance of the arrangement, behind the corporate forms, and enjoined the defendant companies from carrying out the plan as an attempt to create a monopoly of a staple commodity to the injury of the public welfare. Section 627. A combination of capital in restraint of interstate commerce is enjoined. An injunction against a combination of capital in restraint of interstate traffic is granted under the authority of the Interstate Commerce Act of 1890, often called the Antitrust Act, at the suit of the United States through its Attorney General, but will not be granted under that act at suit of a private individual. The combination, if it is against interstate traffic, will be enjoined without regard to whether the restraint is reasonable or unreasonable. The question as to what combinations are in restraint of interstate commerce, like the larger question of what combinations are in restraint of trade, cannot be answered here. A combination of railway employees to strike for better wages and to unionize the road, though in violation of their contracts, is not a conspiracy of unlawful character or in restraint of interstate commerce and will not be enjoined. The latest case from the Supreme Court decides that a combination of the great meat dealers in different states to restrict the competition of bidding on livestock and manipulate prices of fresh meat to be shipped through different states, and secure rebates from the railroads on meat so shipped, with intent to monopolize the commerce of fresh meats, is a conspiracy to monopolize the commerce of meats, in violation of the Act of 1890, and will be enjoined. Once it is determined that the combination is in restraint of commerce within the meaning of the Act of 1890, an injunction issues by express provision of the Act itself. It is to be observed that the federal courts adopt a narrower rule as to what is restraint of trade in the terms of the statute than is applied at common law. Section 628. Injunctions against combinations in violation of state trade and commerce statutes. In many states, express statutes on the analogy of the federal Antitrust Acts of 1890 have been adopted. The difficulty of applying these acts is illustrated in the suit for an injunction brought against the Northern Securities Co. for violating the statute of Minnesota prohibiting combinations in restraint of trade or commerce within the state. Loughran, district judge, in the federal court refused an injunction on the ground that the securities company did not interfere with trade or commerce, but was merely an investor in the shares of two railroads. A directly opposite conclusion was reached upon the same set of facts and the parallel Federal Act of 1890 by the Circuit Court, which granted an injunction against the securities company. This latter decision was sustained by the Supreme Court of the United States.